My name is Gavin. I'm an attorney with a law firm in Grand Rapids, Michigan, and I specialize in insurance coverage litigation. And today I'm here to talk to you a little bit about challenging insurance denials. So 4 o'clock on a Saturday, you've had all kinds of lack of coffee and you're exhausted. We're going to talk about federal laws. It's going to be great. So first things first. I need to apologize at the front end. The good folks at FDRS have accommodated my flight schedule, so I'm going to have to whirl through a lot of stuff and catch a plane. But I want to tell you, encourage you all, if you have questions at the end of this that are just burning and you're not able to get to them or we're not able to get to them, I encourage you to reach out to me. I'm a phone call away. I'm more than happy to answer any questions you may have because we're going to be getting through a lot of stuff here in a relatively short amount of time. So first things first, what I tell you is not legal advice here, and that's an important point. If you have specific questions or problems, I encourage you to consult with a lawyer because the specific facts on your situation are going to be unique, and you're going to want to make sure to talk to an attorney to get some help. With that said, my firm and I do a lot of insurance litigation, and one of the things we're talking about today are health plans. That's the big thing we're talking about for healthcare providers and patients. We're going to start with talking about ERISA. It's a federal law. It governs essentially, this is the legal term, it's the Employee Retirement Income Security Act of '74. It's a federal law, not a state law, which means it's going to govern across the country. That provides some consistency for us. Now, what does it generally do? It's going to provide the rules that govern when an insurance company or when your carrier denies coverage for a surgery involving a lipectomy. So, what does it regulate? Well, it regulates and it governs employer-sponsored health plans. That's the majority of insurance coverages that we're talking about throughout the country. It also excludes certain types of plans, government and church plans, which we don't need to get into right now. But the reason I'm talking to you about ERISA is because it's the general one that's going to apply in most cases. And we're going to give you a high-level view of what you can expect and how you can challenge a wrongful denial. So, digging in, what is a health plan under ERISA? Well, here's the law. It is any plan, fund, or program that your employer sets up to provide medical, surgical, or hospital care benefits. It's essentially just a program of benefits created for you. That's what it's designed to accomplish. The keys here, it's an employer and its benefits. So, as an example in my work, my employer, my firm, creates actually a plan document that says what I get, what kind of benefits I'm entitled to. A few key terms in ERISA. The plan is just that, the plan document that we're talking about that sets forth the terms that's going to dictate what is covered, what types of benefits you're entitled to. The sponsor is the person who actually creates and maintains the plan. SPD is just a summary of the plan that sometimes your employer gives you. And then finally, the third-party administrator are the people that actually process the claims. In my lingo, they're the people that delay, deny, defend their denials. So in any case, how do you know? How do you know if your plan is subject to ERISA? Well, there's 2 ways to check. First, for those of you that are actually beneficiaries, you can actually look. You should receive from your employer or your spouse's employer, if that's where you get your coverage, a copy of a document. And that document should tell you somewhere inside of it, and they're kind of complicated, I'll grant you that, whether or not it's subject to ERISA. If you're a physician in the room, I encourage you to work with your patients to get copies of those documents because they're going to govern much of what we're talking about here today. There's also a mechanism you can look online to get a copy of it. Unfortunately, we don't have time to talk about it today, so I'm going to skip that. What does ERISA do? What are we talking about here when we say it sets the ground rules? Well, a handful of things. It sets forth ground rules for claim submission, timing requirements, what documentation you have to give in support of a claim, and how to appeal, what you have to do, how you can challenge a wrongful denial. And then, of course, it also talks about, and we'll get into this, what the plan has to tell you about why they're denying a claim. So, let's talk about the challenging health plan denials, the 4 steps of claim processing. One is just submitting a claim. Your claim goes out the door for the surgery you've undergone. What happens in response? The plan takes a position in response. They issue what's called an adverse benefit determination. We'll talk about that. Step 3 is your appeal. That's really the meat of it. That's what's going to matter most if you learn nothing else today, we're going to talk about the appeals, because the appeals are the critical step. And then finally, if necessary, sometimes you have to go to court. Now, I know as a litigator that may sound self-serving, but candidly, it is the natural end of this process sometimes. It's just something you have to expect in order to move leverage from time to time to get a payer to step up and do its job. So, submission of a claim can depend and vary if you're a patient or a provider. If you're a patient, you want to work with your providers to make sure that you get the documentation necessary about how much did the surgery cost, what are the billings that I owe. If you're a provider, that's pretty straightforward. You've got your standard billings that can go out the door to the responsible payer. But it's going to matter who the patient, or rather, if you're the patient versus the provider. Oftentimes, your providers are going to have contracts where they're required to submit claims on your behalf. We'll talk a bit about that in a minute here. So, the adverse benefit determination. Well, what is it? It's essentially just when the plan says no. They refuse to pick up coverage for your care. Generally speaking, after you bill a claim, they have 30 days to actually respond and tell you why. And here's the key point. They actually have to do something in response. They can't just say no. They have to tell you why. They have to give you the reasons for the denial. They have to tell you the specific plan provisions on which they're basing their denial. They have to tell you if they need additional information in support of their denial, or if they think they haven't gotten enough information from you about why you think this is a covered benefit. And then they have to talk to you about what the specific appeal procedures are. All of that's really important because, believe me, they routinely don't do any of that. And that actually creates leverage down the road for you when they don't. Plans often screw this up, and so if you're paying attention, you can force them or point out to them that they're not doing the right job. The meat of it, appeals. This, as I said, is the key step in the process. If you take away nothing else from today, take away this. The general rule when it's an ERISA governed health plan is you've got 180 days, a minimum of 180 days under the law to file your appeal. That is a crucial date. When you get that explanation of benefits, that adverse benefit determination where they say no, think to yourself, okay, I've got 6 months. Now, generally speaking, plans are going to, they can expand or contract that requirement up down to as low as the 180 days. So they can make it longer, but they can't make it shorter. So keep that time in mind. Before you appeal then, what do you need? Well, you need your plan document. You're going to need the adverse benefit determination, and then you're going to need some documentation supporting your claim in the claim file. And we'll talk a little bit about that here briefly. So, what is the claim file? I just mentioned that. Well, when the plan decides that they're going to deny your claim, they don't just do so in a vacuum. They actually have to go get some information. They have to decide if it's based on medical necessity or medical judgment. They actually need to rely on the opinions of a physician or someone who has some independent knowledge to support their claim. And so you can ask them for a copy of their claim file. The regulations state that you have a right to it. They have to provide it to you. And I would say ask early, ask often, because they often don't provide it to you. It's just an unfortunate reality of claim processing. The law says one thing, but unfortunately, carriers often do something different. So, what should be in your appeal? Well, as a general rule, it's important that you understand the denial, challenge the denial, and use the plan. Don't just ask the plan to change its mind. And we're going to talk about some specific examples of that. But it's not enough to just say, I ask you to reconsider. That's not going to cut it. You need to be explaining to them why they're wrong. You need documentation. You have to show them why they're wrong. When I talk about the appeal process, this really is your moment. It's your moment to create the record that is going to make a difference in whether or not this claim gets paid. You need to support your position with evidence. Evidence, evidence, evidence. And it's now or never, because when we get to step 4, what you have done makes a difference. If you're going to go to court, there's no trial in an ERISA case. It's limited to the evidence that you presented in the appeal itself. A judge can reverse the plan. They often want to. But unfortunately, they have to give deference. So if you haven't done your job at the front end of putting in evidence, you're not going to be successful. And then on that point, to the victor do go the spoils. Judges are often encouraged to reverse plan denials. You can get your claim paid and sometimes even get your attorney's fee paid. Thank you. So let's talk about some specific examples. One of the more common ones is the plan denies a claim as experimental or investigational. What's our number one rule when we look at that? What does the plan say? The plan is actually going to specifically define for you what it means for covered treatment to be experimental and investigational and therefore denied. So in this case, and you may or may not be able to read it, my apologies, but it sets forth specific language dictating what is and is not experimental. And if the plan, and they routinely don't, by the way, if the plan hasn't read its own coverage provisions and just decided it's experimental, then this is a way for you to challenge their denial. It's routinely the case that they don't explain themselves when they're basing their denials on scientific judgment. And they actually have to. The law says they have to give you an adequate and complete explanation of why it is they're denying for experimental or investigational. So when they haven't done that, you go back and you challenge the denial. Apply the specific language that you find in the plan. If they say, for example, the FDA has to approve it, and it hasn't, well, you can come forward and say, well, hold on a second. We have evidence that supports that actually this is recognized within the scientific community. Here are a number of physician statements that actually support the use of this procedure. Here are independent physicians, not just my treater, supporting the use of this procedure and pushing back and challenging what the plan is saying in its denial. Another example, medical necessity. The plan claims this is just cosmetic. Start with the plan document again. That's our number one rule. What does the plan say? Here, in this case, you'll see, and again, I won't go into all the details, but the plan talks about, it specifically defines the criteria that are met in order for a covered or treatment to be considered medically necessary. So what you want to do in challenge the denial is take that language. Oops, I'm sorry about that. Take that language. Explain with specificity the symptoms that the procedure is designed to treat. What are the symptoms you're having? What are the problems? How is it being corrected through these procedures? Discuss the medical standards within the plan document. Rely on your physicians. Work with your physicians to actually explain to the plan why they're wrong. And what it does do, if you do that properly, you're going to be able to build a record that actually supports if you have to go to court. And in some cases, and I can tell you through very real experience, the plan will reverse itself. If you give them enough support for your position, they can change their mind. I'm going to mention here briefly, there's a couple of contracting issues that come up now and again. Now, in a standard ERISA relationship, you have an agreement with your provider and you have an agreement with your health plan. Sometimes the providers can modify that. And what they do is they create a relationship where the provider has a direct contract with the health benefit plan. I mention that here just because you should be aware of it. So my point in telling you this is talk to your providers. Many of them are in network, and those network agreements are going to impact the definitions we've been talking about, what the time submission and claim submission requirements are, all things of that nature. And I'm going to skip ahead a little bit here because we have only about a minute left. Ultimately, when you get past the appeal process, sometimes, as I said at the outset, litigation can be the natural end result of this. And I would encourage you to consider it as something that is, unfortunately, sometimes necessary. If you're going to pursue that, keep copies, for starters, communicate early. Early is key. If you sit on your rights, you find that those rights can sometimes get waived. When you've hit the wall, when you find out or when you see a plan is non-responsive, that they're not changing their position, you may have realized at that point that the litigation is the natural end of that process. And so the bottom line there is talk to an attorney sooner rather than later, because if you don't act, time may not be on your side. Sometimes plans have contracted requirements as short as 6 months as short as a year or even 2 years in order to pursue the claim after denial. So keep that in mind. Whirlwind, I know. My apologies for blowing through everything as quickly as I could. I'm sorry I can't stay and answer questions, but if you do have any questions, please feel free to reach out to me. I hope it's been helpful, and I'm more than happy to talk to any one of you about what information you may have missed in a whirlwind presentation like this. So thanks for your time.